going over the dilemma of, and I have this right now, if you're denied at an ALJ hearing, assume this is, well, no, let's just talk generally. You're denied an ALJ hearing. What are your options? You always have the option of appealing to the appeals council. However, generally speaking, with some limited exceptions, you cannot then file anew if you are appealing that case, that original application, to the appeals council. And the appeals council, who knows how long they're going to take, right? So you almost have to make a choice. Now, sometimes the choice is carved in stone. You don't have a choice. You have to appeal to the appeals council unless you want to say goodbye to the whole thing. And that is when you're, for SSD, so Social Security Disability, not SSI for that. If your date last insured, and we have videos on date last insured, what that is and why it's important. If your DLI is on a date that precedes your judge's denial decision date, then you have no choice but to appeal, because you don't have any more insured status in which to file a new claim for a new period. So that's a bad situation to be in, but the answer is clear, right? What you have to do. If you're SSI, you never have to worry about the DLI because you're not insured to begin with, right? You're getting the SSI, the needs-based. That's what you're applying for, needs-based disability. So, and that is a thing I am dealing with now with a client, and this is a young person, and I do see things appealable in the decision. But of course, if the person does appeal to the appeals council, he will have to, he can't just go file an SSI claim right now. So the dilemma is, well, the ball's in his court and he will decide by Monday. I'll do either one, whatever he wants. You know, you have to be aware that if you file anew and don't file to the appeals council, you are giving up any of those back benefits you may win or may not with your, don't work with dogs. Hold on a second. For goodness sake. Okay, so if he decides to file anew to keep things moving and not have to wait on the appeals council, and honestly, a big back benefit amount is not the top priority here. A person, you know, this person is dealing with, you know, needing SSI. Things are very dire, very dire. So that might be the way to go, might be the way he chooses to go. Despite the fact that we believe there were errors by the ALJ that might be appealable. I do see appealable issues. Doesn't mean the appeals council is going to take them to heart the way I do and flip it over. And then if they do, it will get remanded to the very same judge who made them for him to redo the hearing and not make those mistakes again. Some people are uncomfortable with that. I've had many a remand. And I've actually never had one that lost. So the judges are always good one way or another about redoing, reconsidering. Of course, you have more evidence that you can bring in, then you can bring in all the subsequent evidence from the first hearing to the second hearing, and that can help. So in any event, that's not necessarily the case. I know that doesn't happen everywhere. So file anew or file appeals council and wait and continue to live the life waiting. I don't know which way it's going to be, but that is your choices. You know, you either file anew or you appeal to the appeals council. The appeals council does have a very low rate overall of remanding, and a much less lower rate for actually reversing. Usually it's a remand. maybe it's a 1% reversal, right? And it's something more than that with remand. Still, vast minority of cases get remanded, but still, if you know you have appealable issues, and you can tolerate the wait. Now, once the appeal decision comes down, if it's a remand, then you just get back in line for the hearing with the judge. You're kind of put back where you were. If it is a denial, then your options are to appeal to federal district court. You can do it yourself. I have known pro se claimants who have done that successfully. Or you can find an attorney who does that kind of work. There are a few really good ones out there. You always have to know that a federal district court attorney, similar to those of us that work below federal district court in the administrative jurisdiction, they're not going to take your case unless they see an avenue to win. Doesn't mean that they can guarantee a win, but they will. Their job, it's very different from the job we have. We are building evidence and advising you on what you need to do to make your evidence stronger and all that, and getting the evidence in and helping you put together your function report and your work history report so it's the strongest it can be while being accurate. They don't do any of that. They are literally dealing with what already occurred, including all the things that you have done in your case before that. So the quality of your function report and your medical evidence. And so whatever's already in the file at the time the ALJ made the decision is what they work with to argue that the ALJ dropped the ball, missed a step, or what have you, something legally based that he was responsible for doing before he rendered a decision, in a nutshell. So FDC attorneys are not a dime a dozen in this field, but they do exist, and some of them take cases in any state. They have a network. So don't hesitate to reach out to them. They will they're going to want your ALJ decision. If you did an appeal, if there was a brief to the appeals council that the appeals council, declined to review anyway, they might want that. They might want your entire file. I usually see them want the ALJ decision, any brief before the ALJ decision, and any brief to the appeals council. It just gives them a few nuggets of what's going on. And, they're going to look at all the objective facts of the case and decide if they think there's an appealable issue. If they don't take your case, it's not that they're saying you're not disabled at all. They just are not finding an appealable issue. And remember, issues of discretion, findings of credibility, persuasiveness, generally speaking, are the judge's discretion. That's what the judge is for. So if it is just a matter of, I disagree with what he found, how he weighted that, that's not necessarily going to suffice as an appealable issue, unless perhaps the judge failed to explain why he gave something more weight than something else, or something that you think is important, no weight or very little weight. So it's really a nitpicky thing. And I have a feeling that they maybe don't take most cases to federal district court, but it's definitely worthwhile having them look to see if they'll take yours. It doesn't cost you anything out of pocket, and it can make a huge difference. So keep that in mind. Appeals council, and then federal district court, or file anew. And again, if your DLI is expired, you're not going to be able to file anew, right? Because you don't have any more insured status. But if it's SSI only, you can. All right. There's a lot of other details to all of this. Of course, I'm just giving you the little, brief synopsis here, the overall picture. But yeah, so I'll find out by Monday if we're going to appeals counsel it or file anew. It's a little heart-wrenching, this one. But anyway, I'll do whatever my client wants me to do on that one. All right. I explained all the pros, cons, and everything that could possibly happen. So now the ball's in his court. All right. I'll talk to you guys later. Bye.